Okay, I think let's get started so we can get you to the reception. I know there was or wasn't a confusion about the time start. My name is Jan Jacobowitz. Some of you know me. We have a few regulars here. And I'm the director of the Professional Responsibility and Ethics program at UM. And it's a wonderful program. You have our little postcard, but for those of you who are not aware of it, it's a course. So the students you see before you who are going to introduce themselves in a moment all get course credit for this. You get ethics credit. It's a big win-win. They spend a lot of time creating the hypotheticals we're going to go through, being clever with them, as you can see, and doing a lot of research and writing memorandum to answer the questions posed by the hypotheticals. The idea, though, is that this is an interactive experience, making ethics fun, right? And so we're going to ask you what you think the answers to the questions are first, because very often when an academic meets reality, you know, there's a little bit of a difference, and so the students learn what it's really like out there, and we fill you in on what the books are saying and the latest ethics opinion. So that's the game plan, and I think with no further ado, I'll just have the students briefly introduce themselves so you have an idea of who they are, and then we'll get going.
All right. Good afternoon, everyone. I'm Jerome Jackson. I guess I should say hello. I'm a current 3L in the program. I've been here. I'm a fellow as well. I've been a student through the program, and now I've come back for a second year as a fellow. I'm from Stanford University, originally from Kansas City, Missouri. And at the University of Miami, I work at the Launchpad, which is an entrepreneurship consultancy. That's a little part-time job I have where I'm a legal fellow there.
Good afternoon, everyone. My name is Tiffany Hendricks, and I am a 2L, a legal intern with the Professional Responsibility and Ethics program. I originally went to University of Florida for undergrad, where I studied political science. Now, in my second year of Miami Law, I'm currently involved in the Business Law Review and the Charles C. Pappy Jr. Moot Court Board.
Hi, everyone. I'm Jackie Frisch. I'm a 3L. A fellow in prep, and I'm originally from Toronto, Ontario. I went to McGill University for undergrad, and at UM, I'm the events editor on International and Comparative Law Review.
Good afternoon, everybody. My name is Sean Abuhoff. I'm a 2L, and I'm an intern in this program. I did my undergrad at Dartmouth College, and I'm originally from Miami, so I came back for law school. Besides prep, I also am a member of the International and Comparative Law Review, and I also am a chair to the Dean's Cup, and I do something else. Can't remember what it is, but...
Well, I think you had a law review article due recently.
I finished it. It was due Friday.
Okay, yeah, and we have Stanford versus Dartmouth football players here as well, too, but we put them on either end of the group. Okay, so let's, you should have two handouts. You don't need that one, except for contacting us. Oh, by the way, we do maintain a blog on a lot of these cases, Legal Ethics in Motion, if you want to check out our blog. The yellow brick road copy is our hypotheticals, and the other is a rules packet, meaning sort of a cheat sheet. It gives you some authorities to take with you, but also if you're wondering what the answer is to a question, it's probably lurking in this packet. Okay? So let's, you can see we have a yellow brick road theme. Let's turn to the first typo called Dorothy's Not in Kansas Anymore. And I don't know, do we have a volunteer that would like to read it? Or Jackie will do it. Nobody's feeling very vocal, so go ahead, Jackie.
Sure. Dorothy's not in Kansas anymore. After graduating from the University of Kansas School of Law, Dorothy Gale interviews with Scarecrow, Tin Man, and Lion LLP, STL, a medium-sized law firm in the state of Oz. Dorothy's interest in the firm is reinforced by her discovery of its Twitter account and a tweet by STL that reads, "STL has done it again. This last win is proof that all you need to do is tap your feet 3 times and we will take care of the rest. Trust us, we will win your case." STL hires Dorothy because she is a skilled legal researcher and an eloquent writer who maintains a personal blog entitled, "We're Not in Kansas Anymore." Shortly after joining the STL team, Dorothy becomes a regular contributor to STL's blog, which is primarily devoted to discussing legal issues affecting Oz citizens. She frequently mentions her firm blog posts on her personal blog to increase exposure. Dorothy likes to write on cutting-edge issues and writes a post entitled, "Up in Smoke, Maintaining a Compliant Medical Marijuana Operation." She links her STL blog post to her personal blog and writes, "I am proud to say that STL is always ahead of the game and on top of legal issues that other firms haven't even contemplated yet. Check out my latest post here." Feeling the excitement of developing an online voice via the blogs, Dorothy decides to update her LinkedIn profile that has remained unchanged since law school. Upon editing, she is asked, "Do you have any of these skills or areas of expertise?" Without hesitation, she selects the following: state regulations, contracts, business formation, and legal assistance. Upon completing all of the steps, she clicks Save and Notify Your Network. Within minutes, Dorothy finds that Glinda, one of her good friends from college, has endorsed her for state regulations, moving this skill to the top of the list. Glinda has also written a recommendation that reads, "Dorothy is the best attorney in town for cases dealing with state regulations. She has always been a hard worker and will stop at nothing to become an expert in this developing area of law. Dorothy is someone you can count on." Dorothy happily clicks Add to Profile and starts envisioning all of the clients that will be following the yellow brick road right to the doors of STL. Questions. 1. What are the ethical implications of STL's tweet? 2. What are the ethical implications of Dorothy's blogging behavior? And 3. What are the ethical implications of Dorothy's LinkedIn activity?
Okay, so before any of us try to answer the questions, just curious here, anybody in the group on Twitter? Okay, we have some tweeters here. Broward's progressive, right? I'm not sure we had tweeting at the last presentation. How about blogging? Anybody blog? Okay, and anybody at a firm that has a blog, even if you're not blogging on it? Okay, and what about LinkedIn? How many of you are on LinkedIn? Okay, a lot of the crowd. And just one other question, how many of you are in smaller practices or your own practices? Okay, so because some of these questions, when you're in a really big law firm, there's a committee handling the answer to these and sending you out directives. Although when we were at one really large firm last year, the associate said they had a policy on all of this, but it was 30 pages long, so none of them had ever read it because they were too busy billing time, right? So what about her tweet? She's tweeting, STL has done it again, this is the last win, you know, in that first paragraph. Anybody have a problem with it? People think it's a good idea?
Guarantees a result.
Guarantees a result? Are you going to say the same thing,
It's a statement
Jay?
or information that can be reasonably interpreted. Our prospective client is prediction or guarantee of success or specific results.
Okay. See, they tweet, they know the rules. So
Yeah.
what do you think, Jackie?
No, that's right on target. The first thing that I should say is that Twitter is subject to the advertising rules because the new advertising rules, which were released May 1st, 2013, apply to all forms of communication in any print or electronic forum. So that includes Twitter. And then absolutely that here there's a prediction or guarantee of result. Trust us, we will win your case. This is promising success, and that would be misleading, and it would violate Rule 4-7.13, which covers deceptive or inherently misleading advertisements. As well, something that's interesting with Twitter that we all have to consider is Rule 4-7.12, which covers required content. You're nodding your head, so you know that.
It's impossible to do given the character limitation.
Yeah, that's the problem here. Twitter, you only have 140 characters. So, and that rule that I just mentioned requires all advertisements to say the full name and the office location. And in 140 characters, if you practice in a firm that has a long name, it's questionable whether you can just use the abbreviated form of the name, and whether if it's linked up, then maybe you can still see the office location on your homepage for Twitter, but maybe not in that actual tweet. So it's very unclear.
We'll pause there a minute. So those of you who tweet, what do you tweet for advertising purposes?
Not at all.
You don't? Okay. Does anyone use it for their firm? Because that's, as Jackie said, right, the guideline says you can use abbreviations, but that doesn't necessarily get you there.
How does this align with the recent court case that allowed advertising results? I got you $1 million, and somebody comes on television and says, this firm got me $1 million, and the Florida bar had to back down from the position that it had taken against it.
Yeah, that's exactly right. That was going to be my next point. But
I'm sorry.
No, I'm glad you said it. You're referring to the Rubenstein case, probably, and that case dealt with advertising past results. Here in this tweet, we have we have the firm referring to its last win, which is referring to past results, and the advertising rules explicitly say, and I'm going to quote it, that a deceptive or inherently misleading advertisement, an example of that is references to past results unless such information is objectively verifiable. So if it's objectively verifiable, then it's okay. The problem is, what's objectively verifiable? That's a very vague term that no one's really understood, and the Supreme Court said, well, objectively verifiable means objective verifiable facts that the statement is true. And in the rules, they give examples of, what would be, here's the example. In a criminal law context, the lawyer may interpret the word successful to mean a conviction to a lesser charge or a lower sentence than recommended by the prosecutor, while the average prospective client would interpret the word successful or won to mean an acquittal. So
let's
That
pause
wouldn't
there
be-
a minute,
yeah.
because there's two cases going on, right? And I'm sure you're getting to the next one. So in the Rubenstein case, it wasn't so much about objectively verifiable.
No, it was about past results on TV advertisements, and that the court the court came out and said, that the Rubenstein law firm was their rights were being infringed. So the guidelines that the Rubenstein law firm was contesting are gone. So now what stands is just the rule that says references to past results unless objectively verifiable. So if it's objectively verifiable, lawyers can refer to past results.
So for the past results for Rubenstein, are some of you familiar with the case? I mean, some of you have seen him on TV. He had his ads approved by the bar, correct? Yeah. And then they issued new guidelines, and they kind of knocked on his door and said, "Whoops, excuse us, we made a mistake." Mm-hmm. So now you have to take him down because we decided that any kind of past results on television, which is what Jackie was getting to, are misleading. And no one can advertise past results. We don't care if you disclaim them, we don't care what you do. And so that failed as being unconstitutional. But now there's, you want to talk since you got us right into the crux of the matter, thank you.
Yeah, no, thank you.
The Cersei Denny case is more focused, right,
Well,
on objectively verifiable as the term of art.
Yeah, and that case is still pending, so we don't have a decision yet on that. The First Amendment claim is proceeding, but
And do you remember the facts of that one? Because it wasn't TV ads.
no, it was statements made on the Cersei Denny law firm's blog, and they made statements. I have a few here. Statements such as, "The days when we could trust big corporations are over." That's one statement. And another statement is, "We have 32 years of experience resulting in justice for clients." Now, what does justice mean? That gets back to the whole objectively verifiable thing, because to a client, it might mean one thing. To a lawyer, they might mean it in more nuanced terms. And so Cersei Denny is attacking the objectively verifiable requirement.
Right, and that case is moving forward. I think they said they submitted 13 pages from their different social media presence, and the Florida Bar found fault with something, at least one thing, on all 13 of the pages. And we spoke to the attorney who's representing them, who said if you extrapolate it out to their entire website, it was some bizarre number, like they might have 50,000 violations on their account. So, yeah. So, and since we're talking about Cersei Denny and blogging, what about that second question? For those of you who blog, do any of you blog as lawyers representing or sort of promoting your services? Or are you blogging about cooking or photography?
I chair the business law section for the American Health Lawyers Association. So we have a blog on issues involving health law, but it's not promoting anybody, it's just answering questions that practitioners have with respect to business transactions in the healthcare space.
So it's more of the organization's
We
blog.
have a Twitter account, we also have a blog.
So maybe more similar to Prep's blog, where we feed it into a Twitter account and a Facebook page,
Exactly.
but we're just writing about current issues. Anybody write about the area of law they practice, or anybody linked to a firm website? Yes?
I mean, I put case updates for my clients. I do a lot of condo and HOA work, so when a new case comes out, I'll write a summary of it, but it doesn't necessarily, I mean, I always am careful not to give advice in the article or comment on whether I agree with the decision or not.
So which is a good idea, or have any discussion, right? So just in a nutshell,
Yeah.
what is blogging subject to the advertising rules, and if so, how do you work with that?
Yeah, so in a nutshell, there's a spectrum for blogs. If it's for professional purposes and you're promoting your practice, it's serving an advertising function, then it absolutely falls under the advertising rules. If it's a personal blog, let's say you're an attorney but you love cooking on the side and your blog is just devoted to blogging about recipes that you try out, then that wouldn't be subject to the advertising rules. But the problem is those two are extremes, and then there's a whole area in between where someone like Dorothy is blogging about personal things but also professional things. There, in Dorothy's case, the advertising rules would apply because she is still talking about her practice and the law firm's practice. And because her blog would be subject to the attorney advertising rules, then that's where we have to really analyze her statements, which again we have similar things that we saw with the first question where she's making a comparison of her firm to other firms which according to the rules is considered deceptive or inherently misleading advertising. And she's saying STL's always ahead of the game, which not only is predicting that they were ahead of the game now, so they're going to be ahead of the game in the future. Like, it's predicting success, but it's also kind of referring to past results by saying, we were then, we will continue to be now.
Okay, and then, because I do want to get to the other issues, a
Yeah.
number of you are on LinkedIn. What do you all think about, are you getting endorsements from people on LinkedIn?
Yes.
Are you accepting them? Are you rejecting them? Do you not know what to do about them?
You don't accept endorsements. You would recommendations. So endorsements are made without solicitation.
But you can show them on your page or elect not to. That's right. So are you leaving them for the public to see?
Yes.
You are. You are. Okay.
But I thought you couldn't say that you're an expert unless you were board certified.
Yes, good point. Go ahead and again sort of sum up what's going on
Sure,
with
I'll
LinkedIn
summarize.
because Florida hasn't spoken to this, right?
Right. So I'll try and be brief. The first issue here is with the expertise. On LinkedIn, it used to say, it actually progressed. It used to say specialties as a heading. Then it said skills and expertise. Then, and now they've removed that. And so it no longer says skills and expertise because of discussions with the Florida Bar. And while that's great, we still encounter a bit of a problem because you're still asked the question, do you have any of these skills or areas of expertise when you're editing your account? So it's just something to flag for your attention because when she says yes and then she posts it, it won't appear under a heading expertise, but she's still asked that question. And according to the rules, you can't call yourself an expert or having expertise unless you're board certified. So that's exactly to your point. And then with the recommendation, Florida hasn't come out with guidelines, but the New York State Bar Association and the Pennsylvania Bar Association has issued guidelines, and they discussed social media and in particular LinkedIn. And the gist of those guidelines say that an attorney is not responsible for the content that other persons who are not agents of the attorney post on the attorney's social networking website. But, and this is a big but, an attorney still should monitor his or her social networking websites, has a duty to verify the accuracy of the information posted, and has a duty to remove or correct any inaccurate endorsements. So on LinkedIn, we all have the power, we can review, the endorsements, the recommendations, and we have the control and the ability to remove a recommendation or an endorsement if it's not true. And we have that obligation too, because we have the ability to do it. And so by Dorothy, without hesitation, just accepting it, on the one hand, she's doing the right thing by reviewing the endorsement and the recommendation that comes in, but on the other hand, she's not complying with the advertising rules by just accepting it when it's not true, and these statements aren't true, and these statements violate the advertising rules for all the reasons we've also already touched on.
All right.
A question on LinkedIn, which is totally basic, but because I don't participate in it, but how is it generated all the invitations to join someone's network? Is that just what generates those?
Their email contacts. There's an option to upload your email.
So everybody
now
just sends them to everybody
takes
they
your
ever
Outlook or your
email?
Gmail or whatever it is, and
It just, they
well, I'll
bombard.
ask you.
Yeah.
But yeah.
Yeah, and then there's an issue that's not in our hypo today when someone does that, if they link to their law firm and you're not a client, a former client, or a family member, then there's a solicitation issue. So we could do several hours on
Just to
advertising.
throw a loop at you. I served as chief legal officer in-house with one client for several years and didn't practice law outside the scope of an in-house position. And by the way, still says skills on my LinkedIn. I just looked at it. So
Skills is fine.
by not being by being in the practice of law, but by not taking on private clientele, does that present an ethical issue?
In what regard?
Well, the rules for advertisement are a result of trying to garner new business.
And
If you're
protect the public.
working exclusively in-house and are not looking to obtain new clients, do the endorsements that you receive on LinkedIn, do they fall within the ethical rule?
Well, I would say, you want me to take that?
Yeah, sure.
I would, because I worked as in-house
Yeah.
counsel as well. I would say that they don't necessarily come under the advertising rules, but they would come under 4-8.4 of the rules, which is the misconduct. So there's an argument going on right now nationally.
Right.
There's a task force on advertising that I'm actually participating in that says, why don't you just use the misconduct rule? It's 4-8.4C here, saying that you can't misrepresent, commit fraud, et cetera, et cetera. Why do you even need the advertising rules? So in that regard, I think if you were a lawyer and you had an endorsement or recommendation up that wasn't true, like Jan's the greatest criminal defense attorney.
For example, I'm a transactional lawyer representing a large company, being endorsed for skill in doing mergers and acquisitions. Is that fraudulent?
Well, no, if that's what you were doing, because I did
nothing
that.
Nothing in the skills or endorsements that were not accurate.
No.
Yeah, if it's
Well,
truthful.
As Jackie was saying, if it's truthful, it's fine anyway.
Yeah.
And
What
I
about the
think,
certification question?
well, and let me just say, I think what usually comes up in the advertising section is, how does the Florida Bar enforce these rules? Because those of us who pay attention know that unless someone calls up and complains about you, they don't have sleuths on the internet looking for you, which as an ethics person, I'm not saying, well, just do it as long as you don't get caught. But that's the certification question. What Jackie was saying is skills is fine. It used to say skills and expertise, and that's
And that
when
was
the Florida Bar went and met with them.
Yeah, so the skills heading that exists now on LinkedIn is fine. But I just wanted to point out, you're still asked that question when you're editing your account. It still asks the user who's editing their account whether you have skills or areas of expertise. So it's still, one could argue it still implicates the rules by asking that question, but on the other hand, it's not displayed for prospective clients or really for anyone else to see as expertise. So so you would argue that it's not violating the rules.
But anybody who does LinkedIn knows that when you're asked that question, you're being asked, do you have an area of expertise? So you're making that representation.
Exactly. So it's one of those things where, we don't have any opinions on it, but it's something that we've noticed.
Would somebody who doesn't have a LinkedIn account even be able to see the skills? I mean, don't you have to have a LinkedIn account? I don't
They
have
can
one.
see the skills, but
Yeah.
it doesn't say that it's your skills and expertise. In other words, Florida went and met with them, and this is how they fixed it. So not sure why they chose those terms that way to fix it.
You cannot review it unless you have a LinkedIn account. But nevertheless, there's many people who are on LinkedIn, so it's still out there.
Right, so anybody who can view it would be somebody who's not LinkedIn who would know that the question is, do you have an area of expertise?
Exactly.
So the public wouldn't, the non-LinkedIn public wouldn't know, but
Right.
somebody who can see it knows.
Exactly.
Is it possible they're trying to get around it by using the word or instead of the
So that's another possibility.
I'm only answering the skills question.
Yeah.
You're
Yeah.
lawyering, you're lawyering LinkedIn. Well, let's move on, so, because we have
Yeah.
lots more fun issues, and the bricks come tumbling down. That's yours, right?
Yes.
So we'll just let you go for it. We're not getting volunteers here today.
And the bricks come tumbling down. Shortly after joining the firm, Dorothy is assigned to work on a case that involves one of the firm's largest clients, Emerald City Construction, ECC. ECC is the defendant in a case in which the plaintiff, Munchkin Mike, alleges that he was injured when a bulldozer owned and operated by ECC caused a tower of yellow bricks to fall on him while he was walking on a public sidewalk. As a result of this accident, Mike suffered a broken leg and dislocated shoulder. He alleges that he has sustained permanent disability and loss of enjoyment in his life. During discovery, Evan Emerald, in-house counsel for ECC and social media fanatic, searches social media for the information about Mike. Emerald finds no information about Mike on social media. Finding it hard to believe that a man as young as Mike and has no social media presence, Emerald contacts Dorothy, outside counsel for ECC, and suggests that Mike deactivated his account in anticipation of the lawsuit. In fact, Emerald's suspicion is right on target. Mike's attorney, Reed, reviewed Mike's social media accounts prior to the commencement of litigation. When Mike opened his Facebook account on his iPhone, Reed saw photos of Mike dancing at a friend's birthday party and participating in the ALS Ice Bucket Challenge. Reed then suggested to Mike, "You may want to clean up your social media account before I file this suit." Mike initially decided to take down photos from his Facebook account. After the lawsuit was filed, Mike deactivated his account, hoping that it would give him a better shot at a huge damage award. Questions. 1. What are the ethical implications of Reed suggesting to Mike to clean up his Facebook account? And 2. What legal remedies, if any, can Dorothy pursue to obtain access to Mike's Facebook account?
Okay, so let's ask a few preliminary questions again. How many of you are practicing law in areas where you're using social media evidence, Facebook evidence? Just a few of you? How many of you are litigators here? Okay, and those of you who didn't put your hands up, you're not seeing any social media evidence yet?
It's not coming up as much in business context.
So you're doing commercial litigation.
Well, I provide representation to judges, so if those issues are coming up, I can't discuss it.
Okay. All right, I don't really know how to approach that.
Well, I'm general counsel for the
Right.
circuit, so
Right.
if judges come and ask me questions, that's an attorney-client privilege, so I
Right.
can't discuss what I know or don't
Right,
know.
you could give us a hypothetical situation. Okay, so this is, as Tiffany's going to tell you, this is coming up more and more. There's new cases coming out all the time, both ethics opinions and case law, where people are going in on motions to compel to get Facebook evidence. And what do you all think about the idea of visiting with a client? And in the corporate world, it's been trademark. There's been some trademark cases where there's been social media evidence that's ended up in motions to compel discovery, things that have been taken down. In personal injury and family law, a little bit in bankruptcy, in immigration law, the Immigration Service is checking on whether marriages are legit that way. But I would say employment law. Anybody in here practice employment law? There's too bad, because there's so many cases coming out of employment law where social media is being contested in a number of ways. What do you all think about telling a client to take down social media evidence? Do you think that they're altering potential evidence, or you think it's okay?
4-3.4 seems to be right on point.
that's fairness to opposing counsel and not keeping them from the evidence. It's interesting that you say that. Did you
Well,
have
it's an exfoliation, that's basically the argument. And it's pretty clear that you can't advise clients. I do family law. And the best I can do is tell people not to post anything. And
Right.
what they've already done, there isn't much I can do about it. But stay off of social media from here on out.
Well, it's interesting because that's been the discussion and the debate, and what you're saying has been sort of the best practice conclusion. But now, just in the past year and just, what was it, in the past month, Florida spoke on
Yes.
their opinion is a proposed opinion, but what are the states saying now?
Yes, well, to start off with, Florida just came out, as Jan mentioned, on January 23rd of this year. They released their proposed advisory opinion on this issue as far as whether or not an attorney can advise their client to clean up their Facebook account or any social media account. Cleaning up could be taking down photos, removing photos, and in summary, the proposal said a lawyer may advise that a client can change their privacy settings on the client's social media pages that are not publicly accessible, provided that there is no violation of the rules or substantive law pertaining to preservation or spoliation of evidence, and they can also advise their client to remove information relevant to the foreseeable proceeding as long as they preserve that data. So Florida, as it stands right now, says that an attorney can advise their client to remove information from their social media account so long as you retain a copy. And this has been reiterated by previous advisory opinions coming from Pennsylvania, New York, Philadelphia Bar, as well as the North Carolina Bar. And this touches on the competence issue of an attorney. Now more than ever, social media is relevant. Almost everybody has some form of social media connections, friends, family. And under the competence rule 4-1.1, it's important that an attorney is competent when it comes to social media as far as how they advise their clients. And pre-litigation, as these opinions have addressed, the opinions have stated it is important that you tell your client the importance of their social media presence. Anything that they post on their social media account can have an impact on the litigation. And specifically, these opinions have all addressed spoliation and to make sure the attorney notifies the client that if they were to remove any information, that can be a sanction against the attorney as well as the client. And specifically, there was a case, Lester versus Ally Concrete, where the attorney had received a request for productions of documents from the opposing counsel where they got a Facebook picture of the client holding a beer can with a t-shirt that says, "I love hot moms." He then instructed his paralegal to tell the client, hey, tell him to clean up his Facebook account. And then the client ended up deleting his account and ended up signing the interrogatory stating, as of this date of the signature, I do not have a Facebook page. He later on reactivated his account during the litigation, deleted 16 more photos without even notifying his attorney. And during post-trial motions, the court ended up sanctioning the attorney $542,000, and the client was sanctioned $180,000 just to cover the fees that they invested in defending the obstructionist conduct of the client and the attorney. And the attorney ended up agreeing to a suspension of 5 years from the bar. And this is just an example how it's so important to make sure attorneys are competent, fairness to opposing counsel, as you mentioned, as far as removing information from social media, because it, of course, can have an impact on the outcome of litigation.
And so Mr. Murray, the attorney, it's a Virginia case, has sort of become the poster child for you better figure out what social media is all about. And I always like to add that when he was asked for, he was, by the way, a prior president of the Virginia Bar. He was a partner in his law firm. He wasn't somebody who just had generally no clue about practicing law. And after he agreed to the 5-year suspension, the ABA reporter contacted him for comment, and they said he wasn't available for comment. He was hiking on the Appalachian Trail. So to which I always say to the students, people must find peace there. People seem to go to the Appalachian Trail. So that's the news. It is a proposed opinion, as Tiffany said, in Florida, but it's still, people are still reacting the way you did. That the flip side of that is the second question: what could Dorothy do to prevent this from, or to get access to his information? And anybody have any idea? How do you have to set up your cases now? I think you could tell that.
Sure, absolutely. Okay, so under the second question, the best way that Dorothy can possibly obtain this these pictures from Mike's Facebook account is to make sure that in her formal discovery requests that they are specifically tailored to social media. For example, the questions can say, do you have or have you ever had a social media account? And you can list out Facebook, Twitter, Instagram, Snapchat, etc. Within the last 5 years. Or if so, please list them. And it's very important that attorneys are specific about this in their request for production, because in the Lester case, for example, he just said, well, as of now, I don't have a Facebook account. So an attorney would never be able to know at that point, okay, he had a Facebook account. But if you specifically write out the questions so that they have to say, okay, maybe 2 years ago, maybe 6 months ago, I did have a social media presence, then the attorney can be able to then go ahead and proceed discovery and address those social media concerns.
So it's a whole new way, really, to practice law, depending what area of the law you're in. In the firms that have discovery banks of questions for requests for production or depot questions, social media now has to come in, because if it stands and if the case law ends up supporting that you can have clients take all this stuff down, then you have to know enough to be asking for it. It's very often analogized to in employment situations where someone has an offensive flyer in the employee lunchroom, and they took it old school, right? Back when I was practicing, they took it down, they put it in a file cabinet. You had to ask for all the relevant documents, and assuming integrity all the way around, then they'd ship you over, 10, 15, 50 boxes of documents, and hopefully you got some good young associates or legal interns that would come up with that flyer, right?
Yeah.
All right, any questions about that?
No, just a comment, but even if Reed does it right and gets his client to just, change his privacy settings and preserve the data, whatever, the fact that the lawyer knows that this stuff is out there means that it limits his claims that he can ethically make, and the claim for loss of enjoyment of life is clearly not available to him, and he shouldn't have pled it. So that even there's a violation there, even if he did all the Facebook stuff right.
Well, that's an excellent point. So the rule, just the number is 3.1, meritorious claims. We all know you can't be filing lawsuits if you don't have a reasonable basis in law and in fact. I'm giving you the ethics quote. So you're absolutely right. So that's the other way this is going to backfire on attorneys if they don't check their own client's social media presence. And their client comes in and says, I can't move, I'm in a wheelchair all the time, and they're water skiing on their Facebook account. Not cool to file the lawsuit.
Is the lawyer obligated to check what's on the Facebook account?
Well, that's the big question mark, right? And the Pennsylvania opinion has come out and said in order to be competent, you need to understand social media. So that's kind of where we're heading. But, that's a debate. That's an ongoing debate.
Yeah, a lot of the opinions are stressing it's so important for attorneys to just be up to date with the times. And there's almost no excuse of like, well, I just didn't know, I don't use social media. Like the opinions are all saying the same thing. You can't just use that as an excuse. You have to ask those questions because the court can hold you accountable to that. Absolutely.
You ought to have different rules for the old guys.
All right. Moving right along, behind the social media curtain.
What age?
I wasn't touching that. I was moving right along.
Judge Berman is here. He can
All right, so on to our third act, behind the social media curtain. Munchkin Mike's case proceeds to trial. During voir dire, Dorothy asks her paralegal Toto to investigate the jurors on social media. After a cursory search, Toto runs across a few jurors who have Facebook accounts, Twitter accounts, and blogs. Juror number 2 has some scandalous tweets and Facebook statuses that fully detail his hatred for large corporations in colorful language. Excited by what he finds on the juror's public Facebook profile, Toto investigates further by friend requesting juror number 2. Juror number 2 sees the friend request and unsuspectingly accepts the request of his newfound friend. As voir dire continues, juror number 2 tweets, "Boring, boring, boring. Hope that I can get out of here soon." After the jury is impaneled, Toto continues to monitor social media. Toto sees a Facebook post on juror number 6's public page that says, "So happy that I made the jury. Can't wait to dump some bricks on corporate America." Toto also checks juror number 6's LinkedIn page, but does not learn anything of value. Juror number 6 receives a message from LinkedIn that Toto has viewed his page. Questions. Number 1, what are the ethical implications arising from Toto's researching the jurors per Dorothy's request? 2, what are the ethical implications with Toto's friend requesting of juror number 2 via Facebook and the LinkedIn message that juror number 6 receives? 3, what are the ethical implications of juror number 6's Facebook post?
Okay, so do we have jury trial lawyers here, litigators that are frequently in trial before a jury? Yes, no, not so much? Yes?
Yes.
Okay. Are you all using social media to check out the jurors?
Yes.
You are? Okay. Are you finding things that are worthwhile much or here and there?
Here and there.
Anybody else? Judge, can we ask, are you seeing attorneys Googling away jurors in the courtroom?
I'm past that stage. I'm a senior judge.
Okay, so you're
I'm
not.
too old to most now.
You're not presiding over trials at this point, or?
Not at this point.
Okay. So this is another area, like Tiffany was saying, that's starting to give rise to a lot of case law and a number of ethics opinions. And I think, Jerome, you can just enlighten us.
All right. So the rule that's implicated with researching jurors is Florida Rule 4-3.5, impartiality and decorum to the tribunal. All right. And so this it talks about ex parte communication with jurors, and that before the trial, the trial of a case with which a lawyer is connected, a lawyer shall not communicate or cause another to communicate with anyone the lawyer knows to be a member of the veneer from which the jury will be selected. Okay, so point blank, no communication with the juror. But where this gets complicated is in situations as we've seen in the hypothetical. When you tell someone to research someone, and you're perusing or reviewing Facebook, their Twitters, their blogs, their LinkedIns, at what point is there a communication? Okay, and so outright things like the Facebook friend requesting a juror, outright wrong, incorrect. You cannot do that. That implicates the rule, right? That's what we've termed as an active review of the communication, of communicating with the juror. You are actively requesting information or requesting access to information, and this is something that the juror sees from their point of view. Now, in the case of let's say Twitter, where they post all their tweets are public, where everything's public and you can see everything, that's a passive review because you're not asking for anything more than what's publicly available. So there you find yourselves within the confines of within the ethical rules, and you're fine. However, social media sites like LinkedIn, where if anyone's on LinkedIn, they know LinkedIn will let you know who is looking at your profile without anyone actually having to request information from you or request access from you for anything. You can see who is following you.
Can anonymously view profiles?
You can, but that's not our hypothetical right now. So in this situation, this hybrid situation that we've termed, where the attorney or the attorney's paralegal or whoever hasn't actually asked for any more information than what's publicly available, but yet there's still a communication that occurs with the juror. Okay, so this has been a largely debated point over the last year, and New York was the first bar association to release an opinion. And so if anyone, is anyone licensed to practice in New York? Okay, so this is interesting for you. Okay, so in New York, the New York bar opinion says that this communication, this counts as a communication with the juror. So though you haven't actively asked for anything other than LinkedIn, what's this person's name and who are they, and started reviewing this, if they receive a communication from LinkedIn, you are unethical. You have violated the ethical rules related to communication with the juror. Now, since then, the ABA has come out with a formal opinion, which has said that communication would not be a violation. They have stated that the communication doesn't occur from the attorney to the juror. It goes from the attorney to LinkedIn, and then separately LinkedIn to the juror. So according to the ABA, you find yourself okay, you're practicing in New York, you may have a problem. I mean, Philadelphia, I believe, has come out with an opinion that says the same thing as the ABA since then.
Okay, and what about what's the standard if you find out that jurors are tweeting and can't wait to dump some bricks on corporate America? I imagine the company doesn't really want that juror on there.
Right.
How are the cases? Just, give us a sort of a thumbnail sketch of what's going on with all these cases.
Well, so as of, I'll say 2012, at least in Florida, the Florida Supreme Court has released more detailed jury instructions, which include no Facebook usage or no social media presence during the entire litigation process. Okay, and so that's become common in Florida since 2012. Now, the rule as far as do you have to report, when you find out that a juror on your panel is tweeting or is posting about this on Facebook, the standard is the rule that's implicated, is 4-3.3, which is criminal or fraudulent conduct, right? And so you have the duty as an officer of the court to report a juror that's engaged in criminal or fraudulent conduct. But tweeting about the trial, Facebooking about the trial, doesn't seem criminal or fraudulent. So what do you do when you see something like this that doesn't quite amount to what the rule talks about? Okay, and this is where we get into, as an officer of the court, you have a duty to report juror misconduct, and this is where you would be obligated to report a juror who is not following the jury instructions as laid out by the judge. The rationale behind this is that if a juror is not capable of following a judge's orders on social media, on staying off social media, how will they be able to apply the law to the facts as in return of a quality verdict? And so as I've said, once you report the juror, now what to do about this is obviously up to the judge's discretion. This is something that the judge has control over, and it depends on how prejudicial this may be to the outcome. In Florida, a juror whose Facebook friended a defendant was held in contempt and sentenced to 3 days in jail. In a case in Corey v. ConAgra Foods, which this hypothetical is largely based on, or loosely based on, where they later found out about the juror who had a separate linked blog and a separate linked Facebook page, which talks about their hatred for large corporations. Sitting on a juror in a case against ConAgra Foods, I mean, obviously this is going to play some part in this. And so in that case, the case had already begun, and the judge removed that juror. In other cases, there have been criminal convictions that have been overturned, but I think everyone here is civil litigation, so don't worry about those.
Yeah. So in summary, it's all right to check anything as long as it's not like a friend request or anything that would be a communication?
Because Florida hasn't directly spoken on this, we
We don't know.
can't say exactly.
Well, we could say that, I think.
Yeah,
Come-
I think
I mean,
so.
you can't, but I'll say that.
I guess it's a public record.
But
Yeah.
on the LinkedIn issue, and where Jay is saying now there's a way to search anonymously.
You can do look at a profile and hide your identity.
So, well, that's like, that's the whole competence thing, right? Because a lot of people don't yet know that or know how to do it. So on the LinkedIn issue, Jerome's 100% right. We can't really say, you know, best practice is probably not to let a juror see you're looking at them until Florida says something.
I think one of the biggest issues, because we use jury consultants when we do this stuff, and they're very conservative, because part of the problem is you start doing that, and then you're gonna have information, and you go from being an advocate for your client to being an officer of the court, where be careful what you wish for, because if it's a juror you like, you're now obligated to divulge. So it gets really, really hairy, especially once the trial starts, when you're still checking on your jurors. At that point, you know, it gets really tough if you find anything that's even questionable, because you have to just disclose.
I think that's right, because if you're, I'm sorry, Jerome, if you're on the plaintiff's side, you don't really, you're like really excited the juror wants to dump bricks on corporate America, right? Go ahead.
No, the point is exactly that, and it's gonna get even more dangerous as time marches on. In doing my research for this issue, we found that a Reuters study that came out, I want to say at the end of 2014, found that someone reviewed the tweet jury duty for a 3-week time span and found that there's someone that tweets while on jury duty once every 3 minutes. 3-week time period, once every 3 minutes about jury duty. So
somebody was tweeting
Yeah.
somewhere, right?
Mhm.
Yeah, amazing.
Did you say the jury instructions say they can't do it at all, or they can't tweet or Facebook about the case?
Now, I haven't read any jury instructions. I mean, I stick to my case books and do the research, but I would assume that it's
You said the
no social media
Florida jury
usage.
instructions were changed in 2012.
Mm-hmm. So, yeah, that they should not be using social media during this time.
At all, it's like an injunction that they can't do it at all?
Well,
or just about the
yeah.
It
time?
depends on, it depends on the judge, but it's typically geared to the case. It's just an expansion of the rule, don't talk about the case while you're on jury duty. So, you know, this is another area where we could spend a long time, but then you'd never get a drink downstairs. Because there's jurors that have Facebook friended themselves during the trial. You know, they're Facebook friending each other rather. Okay, so last but not least, but very short, so we can get you out of here, and something a little bit different. Go ahead, Sean.
A new type of green in the Emerald City. After discovering Dorothy's profile on LinkedIn and reading her blog post about navigating the strict regulatory oversight of medical marijuana plants, Oscar emails ST